It's beautiful Monday. I am here to provide you guys with a bit of an update on the Bryan Konberger trial. I have one of the most recent hearings that was completed 7 days ago, and there's a hearing set for tomorrow. So let's get into this, guys. Welcome, everybody. Replay gang, be sure to drop me a comment. Smash that like button, chime in.
Soon we'll be back with more Bryan Konberger.
TV for this footage. Court TV is on the game.
Welcome back to Court TV Live. I'm Ashley Wilcott. Thank you so much for joining us. We'll get you back to court in just a moment. But first, on our other live
oh my goodness,
trial, abuse and murder trial, Konberger is accused repeatedly to his
forget
in
it.
of 2024 heard a phone call
we can run through this too.
Protection and permanency worker that occurred around 10 a.m. on the day Corey died. Take a listen.
His son's mother then decided that to take it upon herself during the 3.
For you people who are not familiar with this case, this is a case, current trial that's going on right now of a man who is accused of unaliving his own son, physically abusing his son, putting him on a treadmill. I think the son fell off and bumped his body and, was non-responsive at one point, and he had to call.
And he just continued essentially from 7:30 until 1 o'clock in the morning. And I asked what was going on. She would not leave my son's side, and I was not able to be there for my son. And then furthermore, my son that is more, and he was that he had to tell her that I hit him and things of that nature.
That call by defendant was played outside of their presence. We will be hearing child services once again after acted for the jury. Continue bringing you more updates on this trial today. Back to Idaho, where we are following defendant Bryan Konberger. The former criminology grad student is accused of killing 4 each of Idaho students back in November of 2022. The state is making arguments as to why they believe the next thing should be exposed to the
124 sub-72 subsection E, and it would disclose investigation pursuant to 74-124 subsection, where defense's fifth one subparts A through J all deal with the investigation, all to be exempt pursuant to the same authority decided. Subparts M deal with the names of citizens who were interviewed and would constitute unwarranted invasion of personal privacy, subject to 74-104 subsection C. It could contain statements of which would be highly objectionable to a person, exempt under Rule 32 I-2A, or invoke traditional legal concepts in the law of the right to a fair trial, invasion of privacy, under Rule 32 subsection 3. It's exempt under interfering with enforcement proceeding, depriving the defendant to trial, as well as disclosing investigative techniques and procedures. Item 2A names a private business and is exempt under the previously cited authority. Item 2, subpart B through L, deals with the investigation, again, exempt under 74-124A, subsection B and E, as well as Rule 32, subsection E. Item 3 names multiple private businesses. It's also exempt under the same subsections, 74-124A, B, E, C, as well as Rule 32-2A and 3. Subpart I deals with the investigation, exempt under those same authorities. Subpart J involves a private citizen, exempt under those same authorities. Subpart K through B, the investigation, and is exempt under those same authorities. Item 4 deals with IGG information, which have been sealed and is under protective order from the court protecting its disclosure. If the court decides to open this hearing to the public, the state defense will be discussing evidence without any context. This will undoubtedly fuel speculation, lead to assumptions and false narratives. The evidence discussed may not even be offered, and most of it likely will not be offered by either party at trial because it's either not relevant or material. The public will not have any means or context to be able to differentiate that. It is necessary to mitigate this by closing the hearing in order to right to a fair trial for both parties. The defendant makes a public trial, but does not mean right to try this case in it.
Okay, so they are arguing here, Rule 32 in Idaho. I just looked it up. It says any party may use a disposition to contradict or impeach the testimony given by, wait a minute. No, that's a different rule. My bad, y'all. Hold on. Full disclosure. That's what it is. Full disclosure of contents of any pre-sentence report considered by any sentencing. So basically releasing of information as far as, providing what they're arguing now is the defense wants them to publicly discuss some discovery information, some evidence that they have against Bryan Konberger. If the judge rules that the hearing is going to indeed be public, then they run the risk of the public knowing some detailed information that can lead to further speculation. And that's what the prosecution is arguing that they're trying to avoid.
The defendant will stay in court, and the public will have a right to see what evidence this has. But that should be evidence that is admissible pursuant to the Idaho Rules of Evidence. Now is not the time for that. We ask the court to grant the state's motion to close the hearing regarding the defendant's fourth and motion to compel discovery. Lastly, I ask you to issue a scheduling order for the parties to disclose witnesses, exhibits, expert reports, or any other evidence they plan on relying on for those hearings. Prior to the hearing, the state proposed May 3rd, and then a response to those by May 10th. And the state takes no issue with this being a dual deadline. Thank you.
Okay, thank you. May 3rd might be a little quick.
Well, Your Honor,
Marple?
right, but our motion was filed over a week ago.
Right.
So everyone's been on notice of what the state was asking for.
Thank you. Thank you, Ms. Daniel. Ms. Taylor?
Thank you, Judge. Our discovery requests have been filed for months, and they've gone unanswered too. So if we want to talk about being on notice for something, we can talk about that.
Can I just add, because
That is Bryan Konberger's public defender.
I mean,
she is fire.
some of the information it seems anyway. I mean, I'm not. It's hard to know, okay, but it seems like the state has provided and has responded to some of those requests, and some they're still waiting to get that information. So that's the impression I had. I don't know if you disagree with that or not.
I would say the court is maybe in part right, but there's a lot of other parts to those. And the court's referring to our motions to compel, not discovery requests. And so that they do reference a number of discovery requests that have been going out. And we can talk specifically about each of those items.
I prefer not to.
And which is fine. I'm prepared to talk about why this needs to not be a closed proceeding today. But I don't agree that the state is completely responsive here. So I think the court can read and see that they say, we'll get it when you get it. I think the court can read and see when they say, we're not going to offer it, so we're not going to get it. I think the court can read all of those things, and we'll talk in depth on the 10th about what they mean and some of the ins and outs that go into play with those. But there's a lot more than just meets the eye. With regard to the hearing on the 14th, the state directs the court to look at Idaho Court Administrative Rule 32 and Idaho Code Title 74, and really talk about documents that the court can seal. And both really are in, if you look at them, they are to talk about openness of the court and public's right to have information and what things the court can shield from the public and what the public has a right to know. And when we're talking about documents, I brought up that we've filed a lot of documents under seal. We have. Those are documents that end up in the public record that thousands of people read, and file those under seal for expediency and saying, this is exactly what we're from discovery. If the court looks at the documents, and the court can, and probably have, through the year and a half this case has been pending, there are a lot of names and specific bits of information in there. And so expediency, we file those under seal, and for the reasons outlined in Idaho Court Administrative Rule 32. But what we're talking about now is a public hearing. When the state has decided to not give us information or to drag their feet on giving us information, we're talking about a public hearing where we have a right to be in the public eye, a public hearing. Bryan's the one with the right. It's an amendment right to have a public hearing. When the state wants to close a hearing, or any party, and the other party objects, which we do, the court is guided by case law in the state of Idaho and the backdrop of his Sixth Amendment to a public trial in the United States Constitution and Article 1, Section 13 in the Idaho Constitution. So in the backdrop of that, the court is guided by case law. In the specific case, there's a couple of Idaho cases, State versus Lee and State versus Olivine, and they refer the court to Waller versus Georgia, and that 467 U.S. 39. And that puts forth a test that the court should look at when determining whether to close a hearing or leave it open and let it be a public hearing. And that the court has to find that there's an overriding interest that the hearing should be closed. In this case, in this hearing, that's not is what's happening. The court would look at Bryan's rights here to a fair trial and balance that against the state's request to close the hearing. And we would want the court to consider this, that this isn't the state trying to protect Bryan's interests at all. He has the right to the public hearing. This is the state trying to protect him. And the court should look back through the history.
And the defense also laying out a good case, citing case law about why this should not be a closed hearing, that there's an overriding interest does not exist to be open. We're going to hit the pause button. When we come back, of course, we'll get you back in for more of the arguments in this case. Will it be under closed hearing? Stay tuned.
With a trial of doomsday prophet,
Guys, if you're enjoying this video and this update so far, please be sure to give me a like, and share. This is the update as far as where Bryan Kohberger's case sits. There's a lot of preliminary hearing stuff that they have to work through. And I'm following it on the back end because, like I said, I don't know many people. And there may be people out there like me who like to follow trials and stuff like that. So I'm going to continue to share it and hopefully find those people. All right, y'all.
Penalty against him.
Investigators have recovered human remains at David's residence.
Has already been convicted.
Now will her husband end up with the same fate?
So hard to know where the truth ends.
It's the Doomsday Prophet, Chad Daybell, on trial. And welcome back. We are watching the motion scene underway for Bryan Kohberger, the man charged with killing 4 University of Idaho students in 2022. Today's hearing will determine whether Kohberger's next hearing, scheduled for May 14th, will be closed to the public. Right now, attorneys are making their arguments before the judge. The defense is now arguing they want this to be an open hearing. Let's go back in to hear more.
What's your credit card? $10,000 or more. Free, easy.
Motions to compel 1, 2, and 3 were public. Right out in the open with the public. The specific discovery requests were also sealed. So this has been a pattern to do things in the public. And now this one needs to be sealed. The court has to ask itself what? And the court should ask itself, what is the state trying to hide here? The things that we're seeking in these to compel are things that are outlined in a probable cause affidavit that has been public for a year and a half now, that has been offered to be shared far and wide. We're looking for things like videos that the state said they collected so that we don't look at things in a little vacuum. The state tells you not to take it out of context, but that's what they're doing. When they want us to do this in private and not let the state know about the full scope of the videos that are out there, that they have, that is the state keeping things in a vacuum to control the public narrative. And that violates Mr. Kohberger's rights. That's what we want to prevent. This needs to be out in the open. Here, I'll give you a couple of examples. The state filed last June its motion for protective order of the IgG materials. That motion was filed in public. It's on the public record. People can print that and read that and do all day long. And that had information that was negative about Mr. Konberger in it. So that's out there in the public. But that order was to protect information, the IgG information, that they say details how the state got to Bryan in the first place. That's been sealed. That's fine. We respect that. But you have to question, why can we not talk about the things they're not giving us? Why can we not talk about the cell phone information, the tower information, the drive test information in a public arena? Why should Bryan have to have his case when he's asking for this information be done in a little vacuum where the state says what the public can hear and what the public hear? Another example of this, Your Honor, is with the video tape that they've relied a lot on in the probable cause affidavit that we've received different parts of. Part of the hearing on the 14th is to talk about the different parts of that video that we've received and how we need the whole context. This is the video that they say places this car near the residence. We've received little tiny pieces of that. And we think Bryan's right to a fair trial means the public needs to know that they withheld the audio from a great portion of that. And it starts a long time before the little clip that we've received. To do this in a vacuum, Judge, when documents filed under seal, that's fine. Those are documents, but this hearing needs to be in the public eye. For the court to allow the prosecutor to say, we need to keep this all private for a fair trial, really ignores the public nature of the case. It really ignores the fact that Bryan essentially.
She is making a good argument because there is a lot of information out there and a lot of speculation. You know how it is these days. When something happens, you're guilty until proven otherwise. It's not innocent until proven guilty in social media. Similar to the case with the pastor, the recent case, that young lady who unfortunately unalived herself in North Carolina. Everybody thought the husband did it. Everybody. But, you know, because I follow cases and watch trials, I bear in mind that the state has the biggest burden. They have the biggest burden in order to prove guilt. And I hold them to that. You know what I'm saying? I hold them to that. With DNA and technology and cameras everywhere, you know, the state would have to provide sufficient evidence for conviction. And in the case of that pastor, I think that's one of the reasons why the police released the his wife's 911 call, because in the court of public opinion, he was guilty. He did it because he did other reckless, immoral, no integrity behavior. Cheated on his wife, allegedly. Just very callous as a person, but didn't make him the person who did it to his wife. So I feel her. I feel the defense on this one. This hearing needs to be public because there's a lot of other information that is out there that has painted quite an interesting picture of Bryan Konberger. Like a lot of information. If you Google Bryan Konberger right now, it's endless amount of videos upon information out there about him publicly. So, his defense team, his attorney, she has a very valid point.
Convicted in media. You don't have to read a few articles to see how negative they are about him. He has a right to have this information withheld, brought out in public, so that it's not this neat little package, so people can start to wonder if Bryan's innocent. Your Honor, Bryan is innocent, and he has an absolute Sixth Amendment right to have his hearings in public. We think if the court allows the state to shield the information and how they got their information and what they don't want us to have from the public, they're using his Sixth Amendment rights to hide behind. And that's just not what the court should allow. We strongly object to these kinds of things being closed.
Thank you, Ms. Taylor. I don't know where to stop, though. I mean, if we start pulling out all the potential evidence for the trial, before the trial, then does the state get to respond to that? And that's where does it start? I mean, it stops. It just is a lull of that. And so either side, okay, it sends to the public that it is not, you don't get the contest. They don't have the contest, the public. You have the contest. You want more contest. I get that. But really difficult to just open that up and talk about particular issues in the case without talking about the entirety of the case. And that's what trials are for. I mean, I totally understand Mr. Konberger has a constitutional right to a public trial, but having a hearing is not a trial. That's something different. And so that's why, that's where the balancing comes to, if you want to.
I do, Judge. the Waller versus Georgia case is in a context of a motion to suppress. If the court starts closing hearings now, when the court can close the other motions to compel, what's the court going to do when it comes time for a motion to suppress? Those are coming. Many of them are coming. We want the hearings in public. The state has dropped the information with different filings they've made all throughout the way. This can't be done in private.
I would say both sides have said in their motions or their briefs that they disclose, certain things, and it's a change. See that because both sides have agreed to seal a lot of these issues of evidence in the discovery, and so all of a sudden it just does feel like it's moving in a different direction. But I understand what you said. It's like this isn't about discovery. This is about the hearing.
Your Honor, the discovery documents, and there are things in there that the state's chosen to respond to. The state selected which things that we have to have a hearing about, and these are about things that are in the state's possession or control that we want them to give us, and we're asking you to order them to give us these items so that we can do our work, so we can complete our investigation. It's not any different at all. Sealing the documents, I think that needs to continue to happen. That there are a lot of names in those documents and requests for follow-up. We don't have to do that. I do think those are fine, and I think they're different because they're documents that are going to sit in the public record, that are different than having a hearing of things that the parties haven't been able to resolve on their own that the court needs to resolve.
All right, still with us, trial attorney C.K. Hoffler. C.K., the court said something that I was thinking as well, which is, well, this isn't a trial. The Sixth Amendment provides for a public trial. This motions are slippery.
Where I don't want to preview all the evidence in the public release. So to some extent, there's been a public case. This is not the first, nor will be the last high-profile case where there are high stakes and where there are 4 murders. And so I think the judge just has to take every single issue under advisement and make a determination.
I agree with you, but CK, to your point, it's interesting. The defense is saying we want it open. The state saying we want it closed. I think that's though because the defense wants it open. It's a motion to compel against the state. That's the whole reason the defense filed this. It's an underlying motion in the last seconds. We're almost out of time. Do you think the whole reason the state wants it closed?
I think the state wants it closed because I think the state wants to have a surprise element, not ambush, but surprise element.
I think you're right. CK Hoffler sticking around. Stay with us. We'll bring more of the Konberger hearing here on Court TV, your front row seat to justice. Welcome back to Court TV Live. I'm Judge Ashley Wilcott. Thank you so much for joining us this afternoon. We are in 2 Idaho courtrooms this afternoon here at Court TV. First in Boise, self-proclaimed doomsday prophet Chad Daybell has been facing his own family members today who are testifying against him for the state. Wow. Faces the death penalty if he is found guilty of murdering his first wife Tammy and his new wife's 2 children, Tylee and JJ. Of course, Lori Vallow already serving a life sentence for those murders. We're going to get you back into that courtroom next hour. And we are also in Idaho, where suspected killer Bryan Konberger is back in court for a motions hearing. The former criminology grad student is accused of killing 4 University of Idaho students back in November of 2022. Right now, the state is arguing that an upcoming hearing should be a closed hearing. The defense is objecting to that based on the defendant's right to a hearing under the Sixth Amendment. Let's get you back into court for more of the arguments.
I'm Frederica. I'm 33 years old. Can I
Hold on, y'all. Bear with me.
kick off for 1 year?
My bad, y'all.
how it's carried out. My interest is Bryan's right. But I would ask the court to remember the history. We've had motions to compel 1, 2, and 3 in the public eye. All of a sudden, we get the 4 and 5, and we understand the subpart of 5 that has to be in a sealed proceeding. That is going to directly deal with documents the court has ordered be protected. That's completely different than when the state won't give us bits of information that's within mission control that we need to prepare our case. Your Honor, I would ask the court to consider, too, how much pressure there is to get to trial. We've heard the states say they'd be ready by this summer. We've heard the states are going to be ready by March of 2025. We've heard them say that they've given us 95% of discovery. We've heard them say they've given us all of the discovery, and those things just aren't true. Not true. You can see from the list of things we don't have, there's no way we have 95% of it. So when there's all of that in the public eye and the pressure, and let's get to trial, I think the public has a right to see, and Bryan has a right for the public to see that we're trying the best that we can. The court offered to do what it could to speed this up. Having hearings about things that shouldn't be closed, that we object to being closed, takes time. There is no in our habit or our practice filing documents under seal for things that meet Idaho Court Administrative Rule 32 subsection I, and us asking for a public hearing. There's nothing inconsistent about that, and that's the way we've carried out the case.
Thank you, Taylor. Response, Mr. James?
Yes, Your Honor. Taylor's argument and multiple completely false narratives are the exact reason why this hearing should be closed. Yes, defense has a right to a public trial, but that is not the right to having all hearings open to the public. The court's right. There will be a date for this, and that is the trial. But we shouldn't be discussing all the evidence that we're going to hear at trial prior to that. There's no right to try this case in the media. The case law that the defense relies upon has not extended this balancing test to these types of hearings. The hearings are about, or the cases are about trial, and yeah, they extend it to a suppression hearing, which was so interrelated to the trial. Waller v. Georgia primarily stands for the proposition that any closure gives you this balancing test. We just went through the balancing test, and the state gave you the reasons for why this meets the test for closing the hearing. As far as being inconsistent, I would just note for the record, we have had one hearing regarding motions to compel. However, at that hearing, this is your order. At the outset of the hearing, the parties informed the court they had reached agreements on all issues except request 160. We discussed one request, and it had to do with training records. That is not what we're discussing at this hearing on the 14th. I've gone through the multiple issues and subparts, as well as the reasons why we cannot have this discussion in an open forum.
Thank you. Want to respond to any on that, Ms. Taylor?
Your Honor, we had the entire IGG state's motion for protective order and our objection to that in a public forum as well. That ends up resulting in agreements that the court had a protective order on, and we can even share with our investigators that come to court with us. And we've abided by that, and we understand that. But the entire hearing leading up to that was done in the public. In that particular hearing, they talked a lot about DNA results on a knife sheet. That, I'm sure, benefited the state to have that in the public eye. What we're going to talk about on the 14th, Judge, I don't have to name any private citizen names. I can talk about records exist and why we should have them without naming private citizen names. I can talk about the videos that they've not given us. They're not about the business. They're about videos that were collected by the police. I can talk about those in the context of the police reports. And by the way, those are all things that are talked about in the probable cause affidavit. And I can talk a ton about the cell phone information, the cell tower, and the things that they have not given us, the dry test information, verification of. Josh.
That's the thing. I don't want to talk about those particularly, and I guess I'm reminded, okay, in your comment about the IDG, because once again, I'm in a position where I have to make decisions blindly to some degree, and that's what the case with EG. I mean, I had to go through all of that information, and then I provided most of the information to you, okay, to the defense, so that you could evaluate that. I feel that the same way about all the. I mean, there's a lot of stuff, okay, that you're arguing about, and the state is arguing about, and I think it's complicated to just open that up. I think that maybe we could go through a closed hearing and then open up what you feel needs to be opened up. I can't make that decision in the abstract. So that's my worry, because I went through all this last night again, and how do we really fairly deal with each one of those issues? There are a lot of issues.
I agree with you. There are a lot of it. I would ask you to look at the probable cause affidavit and read parts where they talk about relying on FBI agents and the CAST report and different cell tower data. Your Honor, that stuff's in the public eye. Why can't I talk about what they refuse to give me in the public eye?
Well, one of the things that we want to talk about today is I just got motions for subpoenas to take them to the FBI. I mean, it's really difficult to get information from the FBI. You know that. They know that. I know that. We have we have to jump through a bunch of hoops to get particular information from the FBI. That is not the state's issue, although maybe it should have happened 6 months ago.
That's the state's issue.
I understand that. But that is one of the things maybe addressed that today, too. I don't think, thinking that you don't have an objection for you to sign the subpoenas.
No, Your Honor, I don't have an objection for the court to sign the subpoenas to try to get the information.
So I can sign that. I can sign that today.
You can sign that. You can sign that. Anything you need to sign to give us the things we want, please sign.
I'm with you. I'm trying to do that, and from what I've seen, I think the state is trying to do that. I know that it's not satisfactory from your position, but there's a lot of issues in this case.
And Your Honor, that's really a lot of what we're going to talk about on the 14th is the timing of these things.
Right.
Not the full content of we think these things might show. We don't know. We don't have them. They know.
Likewise.
So I think the timing is important. Your Honor knows how much pressure there is to get this case to trial. Your Honor also is aware of all this that we have to do. And when we make a request and months later you're asked to sign the order so that maybe we can finally get that information, that time part is important for the public to know. The content, I'm not going to talk about the content of that subpoena you just brought up. I don't need to talk about that at all. But I can talk about the delay in this and why there's a delay in us trial. That is fair game for the public, and that is something Bryan has an interest in having public. So I don't have to talk about that content. That's not the issue at all. But the things that are laid out in the probable cause affidavit on.
She definitely wants the public to know that for whatever reason, the prosecution has delayed giving them items of evidentiary value. So it's making their position as far as presenting an adequate defense for Bryan Konberger extremely difficult.
Public web for a year and a half now, it makes no sense that I can't ask for those things in the public when they're things that the state said they relied on. That just makes no sense. I have one more ask when we're done on this issue.
Okay, thank you. I mean, are you expecting to make this decision right now? Maybe not.
Well, Judge, you should just make the decision to have the hearing open. If I start to talk about content, then maybe you can talk about it then. I don't agree any part of it should be closed. Any part of the hearing should be closed, and I think you should make the decision now. We're 2 weeks away from this hearing.
Oh, 2 weeks? Is that right? 4 days?
4 weeks. We're 12 days.
All right. Well, I kind of mentioned this a moment ago. I just feel like we need to get into the details, okay, of all these issues before I open it up. So I'm going to close that hearing. Now, that doesn't mean that after we sort out all of those issues and I have more understanding of why you're getting what you want or what you asked for, or whether or not there is something that you've asked for that doesn't exist, or that some of the materials are with the FBI, and that we get that. I mean, those are all really complicated processes, and I would feel much more comfortable. Again, I'm trying to protect a fair public trial and not have maybe not intentional unfair hearing, okay, that goes out to the public. I think that's the bound for me. That I want to see what all the issues are, arguing both sides, so that I can make a more informed decision.
All right, the judge decides and grants the state's motion to have a closed hearing on May 14th. Stay tuned when we come back inside that courtroom for more on the motions.
Today on the closing arguments, live message said child killer Karen Reed.
Excuse me. At least 4 University of Idaho students in the middle of the night in their off-campus home. Konberger's defense says he was simply out driving that night, looking at the stars. Right now, the attorneys are arguing over an upcoming hearing and whether or not the hearing should remain open to the public, or rather, a closed hearing. Let's go back in where we left off.
Maybe we can open up part of it. I need to dig in, and you all get into exactly what is the problem with each one of these issues. All right, so let's talk about the schedule. Okay, the state asked for this, some disclosures of witnesses, expert witnesses, exhibits by May 3rd. I don't think that's particularly practical at this moment. I know that you had, and I'm not looking at it right now, you got another idea about that, Ms. Taylor?
Judge, I think I had May 7th.
Okay. Seems more practical. Okay, so I will put an order out, schedule order for providing. I I don't know if the state really knows what you're to do until you see what they have. And you're shaking your head, yes.
Yes, sir.
And that means that maybe you don't have any witnesses, expert reports at this point because you don't know what to expect. And this is related to the hearing on the 16th, right?
In the 14th, actually.
Okay. And there may be witnesses on the 14th as well?
Yes, sir.
Okay. All right. So let's make it May 7th for disclosing witnesses, expert reports, and exhibits. We'll see what the state has to do with that, and we'll have a response maybe May 10th. Is that sufficient?
Okay.
It's tight.
Well, that gives us 3 days to make a response.
3 days. Yeah, that's right. Well, May 10th is I don't read all that stuff too because it's 14th. So if I don't have it by the 10th, then you're saying the 13th. I guess I can do night of the 13th. But also, the defense needs some space there too. And I don't think we want to put out that hearing. Can't do it by the 10th.
We have no idea what the defense plans on doing, and that only gives us 3 days to read, comprehend, and respond.
We'll deal with it. We'll deal with the 13th.
Yeah, I mean, we can, and then if we need more time, we'll ask for more time.
It's just my end, you're looking at, I'm going to have really more time.
Your Honor, I don't expect reports. I expect to provide a witness list.
Okay.
I don't expect there to be reports.
Exhibits?
There may be exhibits. I think there will be at least 2 or 3. I know some will be things that they've already given us in discovery, so they shouldn't be new and surprising.
Okay. I mean, it's hard to have these tight, time frames because we also have other things, but Mr. Thompson?
Your Honor, it's completely unfair and unacceptable for us to get a list of witnesses with no idea what they're going to testify about. The names of witnesses don't mean much of anything. And unfortunately, we're having a pattern in this case, last-minute disclosures of witnesses and PowerPoints and all sorts of things that frustrate Your Honor's ability to assess what's going on because it's brand new to you, just like it's brand new to us. And I think that practice has to stop. We need substantive disclosures. If we're offering experts, the rules of discovery specify what you have to disclose regarding an expert, and that's not just the name. So it's being propounded by the defendant right now simply isn't within the rule. It's not appropriate. It's not fair to the court or to the state.
Okay. Well, I mean, you don't have to have witnesses or exhibits, but you can have a response to say, well, this isn't fair, whatever you want to say. Otherwise, I just need to push out this hearing. I'm outside.
I appreciate that, Judge, and I guess we've said before, it is more important to do it right than to do it quickly. If we have to have a trade-off here, and that includes fairness to everybody involved, including the court. And I would prefer that this not be kicked off, but we're realizing that we're 2 weeks, essentially 2 weeks or less away from these hearings. That apparently there are going to be a number of witnesses that nobody but the defendant knows who they're going to be and what they're going to try to say and then react in court. That's just simply not the way to operate an effective, efficient, fair process.
Well, let's explore this. I mean, how many witnesses are you expecting to have?
We're going to have 2 on the 16th. At this point in time, I'm not expecting either one of them to write a report. I expect a couple of exhibits. Some will be things from protected materials that the court allowed us to have already. There will probably be one or two other exhibits, maybe two, that the state hasn't seen before. I can provide those. I intend to provide those. On the hearing on the 14th, I think there may be two witnesses. On that hearing, one for sure. We haven't made that determination yet. If there is going to be any PowerPoint presentation, I will provide that to the state as well. If we have an expert who hasn't written a report, then we won't offer expert opinions. We'll offer opinions about why we know the discovery is available, why we know these items are available. The state knows full well what they have and what they're withholding from us. And that's, I mean, it's not going to be about what they're going to show. We don't know what they're going to show, but we know they exist.
Thank you. Well, I just want to have this hearing. I don't want to push it out. All I can say is do your best. I'll be fair about it. I'll give you more time to respond if you still have that time. That's kind of where we are. And I just want to keep going. I mean, we got to get through all this discovery stuff so that we can get ready for the trial.
Well, and Judge, I do, for the record, need to clarify, the representations of the defense that we are intentionally withholding things that they're entitled to is just utter nonsense. We have strived. We are continuing to provide additional discovery.
I will say this, both sides are very zealous in their advocacy. Let's bring back in Charlotte for jumping us. I would release Shannon, the attorney for the see what the judge does. Welcome back to Court TV Live. I'm Ashley Wilcott. So happy to be with you. We are watching now the remainder of the motions hearing for Bryan Konberger, the man charged with killing 4 University of Idaho students in 2022. The judge has decided to close his next hearing, which is scheduled for May 14th. That will be closed to the public, and that's on motions to compel. Right now, the court is ironing out some court logistics and administrative matters. On the back end to hear more.
Record.
They had to file a motion to compel on instead of the intent and wait because their discovery deadline is in September. That we'll have and be able to make that available between now and the hearings on the 14th. And there may very well be little of anything we have to fight about. Your Honor also noted there are some things that we simply do not have the power to access. And we are trying, we have been trying consistently through operative efforts as well as following the process with the federal government. They have been good partners, but they have their own rules to work with. This isn't the motions for the subpoenas to speak isn't the first 2-week process, and the court is aware we've been pursuing 2-week process for all types of information for months. So the characterization that we are just withholding information to frustrate the defense is utter nonsense. That is not true. We will provide everything we can that is providable under the rules. If we disagree on something, whether it exists or not, because I can tell you, any of the things that the defendant is trying to itemize, when we talk to our people, they say that doesn't exist. So, I don't know what we're supposed to do with that. We'll flesh it out at a hearing. And it may be that if they have experts who are going to say, well, such and such should exist, we might have to find experts to say, well, in this case, it doesn't. Or no, we'll see.
Well, that's exactly why I want to close it on the 14th, because we're going to have many arguments, apparently, about issue by issue by issue. And some of that should not be out of it.
Thank you.
Your Honor, I want to respond to that, and I can give you particular things. And it's already been ordered, given to us, the cast report, which was a draft that we were promised to have by March 31st. It's May 2nd. We don't have it. So for the prosecutor to stand up and say that I'm misrepresenting things, he's misrepresenting things. That's
Let's not go there. I mean, we can sort that out on the 14th. I mean, I read everything they were saying.
Hey, Chantel. Hey, Apache Native. Hey, Michelle. Hey, Yo Son. Hey, Psychology in Calais. Hey, Saint Hudson. I said it in the comments, but I wanted to verbally say it. This case in this hearing is about Bryan Konberger. Bryan Christopher Konberger. He is the graduate student in psychology and criminology that is currently alleged to have unalived 4 college students. I believe all of them are age 21. 3 girls and 1 guy in an off-campus college house in Moscow, Idaho. This case intrigued me very much because they say that the state says that they have DNA evidence that links Bryan C. Konberger to the unalivings. So it's unfortunate that they're going to close the hearing that's scheduled for tomorrow, but I understand why, because they're probably going to go through a lot of the discovery. A lot of the information on this case, by the way, has been sealed. Motions have been filed under seal to protect the privacy and to ensure that Bryan Konberger gets a fair trial. So his defense is really doing an amazing job. She is Trump tight, I'm telling you. She's vicious. She's really good.
Okay, you're integrity. So I don't want this pointing the fingers back and forth. I don't think it's very helpful. Doesn't really help me. It started at the last hearing, and I really want you all to just tone it down a little bit. I mean, you can argue all you want, but when it starts to be personal, it's destructive. I mean, you're really, really good lawyers. So let's just focus on the issues.
Your Honor, we're happy to, and when we get a cash report, we'll disclose it. We do not have it. We are not reporting. As simple as that.
I read that last night. Okay. I'm fairly prepared about what the issues are, okay, about the discovery. And that's why I want to be able to hear from both sides, okay, what is the problem with this? What do we need to go forward? And I'm going to try and help that. And I expect that both of you do the same.
Your Honor, I do have several other examples, but in light of what the court said, I won't provide them right at the moment. There are other issues.
I understand, and I understand your frustration, and it's a big deal. It's really important. I understand that too. I acknowledge that. Sometimes, we just can't quite get what we want from other people who might have it that don't want to give it up. So that's one of my challenges on the 14th and probably at the 16th too. Okay. Moving on. We've got all right. Some of these pending motions, there was no response from the state, and I'm thinking that the motion to unseal parts of the IGP materials and motion to allow defense investigators to review the IGP materials, that we're going to be addressing that on the 16th. Is that?
Yes, sir.
That's that's the state's understanding. Ms. Taylor?
Yes, Your Honor. We're happy to have a hearing on the 16th for both of those issues as well.
Great. I'm just trying to make sure that we're all on the same page, or at least the same date. But I wondered, okay, there's been a response on the alibi issue, and I don't know if there is a request for or
Well, the alibi is really wild. It is the defense's assertion that Bryan Konberger was just riding around in his car the night of the M words. So he couldn't have been the one to do it. And he was also riding alone in his car. So there's no one there to corroborate his alibi. So there are definite issues with that alibi.
for now, I don't know. What was your intention there, Mr. Thompson?
I think at some point we're going to need a hearing on it. We're busy enough for the next couple of weeks with these other hearings, so we haven't reached out specifically on that.
Okay.
If the court would like to select a date while we're together today for a hearing, we would be happy to.
Why don't we just wait until the 14th or 16th?
That's fine.
And there may be issues that come out of discovery that have some bearing on that issue. I don't know. You don't have to say anything. It can read your mind. Something, maybe not. All right. Okay, I'm going to sign those subpoena duties taken. The FBI. I believe that's related also to the 13th supplemental. I'm kind of moving back.
Your Honor, it does relate to one of our discovery requests. And I'm sure one of the number of motions to compel. I'll note that when I speak about that in the 40th.
Okay, great. All right. Are there any other issues that we need to address today? Yes. Mr. Thompson, Ms. Jennings?
Hey, midwife.
Ms.
Hey,
Taylor?
Michelle. Hold on, y'all.
Yes, Your Honor.
Okay.
Midwife. Hey, how are you? I'm so sorry. You know I can't see, and I ain't doing no screenshot either. Hey, midwife Kay.
I want to say this in a way that doesn't come off finger pointing, because it's not. This is about how busy everybody is and how much time it takes to communicate to get hearings set, because there's a lot of people going a lot of directions. I would like the court to consider setting hearings twice a month, every other week, and the court vacate those hearings if neither party notices something up for that hearing. There would be 14 days notice for either party if we have hearings on that basis. But that way we could note up specific hearings and just have those set dates so that we're not bugging the prosecutor's office for a stipulation and bugging the clerk's office for hearing and waiting to find that out. It would speed things up to have 2 times a month that we would, if I've got 14 days before this hearing, I can notice it up and it can be heard by the court. So that's a request to the court. Just reset a couple of hearings. These would not be like motions to suppress that we'll probably need a couple of full days for. These would be these shorter motions that we could deal with in 1 to 2 hours.
All right. Thank you. I actually mentioned that at one of our hearings. That's what we need to do. I think it would be more helpful to, I guess, have better communication. Okay. I don't know. Maybe you are having good communication with each side. It is hard, to get a hearing when the clerk has to contact you, contact Mr. Thompson. This goes back and forth. I mean, it takes a lot of time for your assistant, the clerks. At the same time, I have a lot of other cases. And I have a lot of jury trials going from here really to the end of the year. So it's hard for me to say, okay, we're going to have it I think I offered Thursday, like a Thursday afternoon. So I'm willing to do that. I might just set like once a month, maybe, and then if you need something more, just let us know. But I'll look at my calendar and set that up. I mean, I know you come down on Thursdays generally. Okay for you, right?
Thursdays or Tuesdays are fine. Fridays are fine. Wednesdays are rough, but whatever day works for the court, I'll make it work. I just think it's more important that we have a place with these hearings so that everybody's not spending a lot of time asking each other what day's okay, what is okay, that we just all know that this is whatever day works with the court schedule, Your Honor, is just fine for me.
Thursday afternoon is probably
That'll work.
Monday is impossible. So what about that? Ms. Jennings?
Yeah, but makes sense. Thursday afternoon be fine for the state.
Do you think twice a month? It's probably going to ramp up.
I suggested that just because then there's 14 days to the next hearing, so everybody would always have enough notice. That's why I suggested that, and to know that we have those that are to our ways. Again, these aren't the motions to suppress; those will come later.
Maybe we'll start with twice a month to get through all this together. I hope we can all get past that soon.
I would say very smart to schedule hearings in advance for motions. Before we go, I want to share today's thought.
Okay, guys, so that was the hearing. The hearing that's being held tomorrow will not be public, unfortunately. But I do understand why. I don't think they want everything on the table in front of the public just yet because it's not the trial. This is a trial that I am interested in attending. However, I'm hearing rumors, y'all. I'm hearing rumors that the defense wants to call upwards of potentially 400 witnesses. I'm like, wait a minute, what? Do you know how long it would take for a trial to have, like, this is shaping up to be like the Young Thug trial. Like, it's going to be forever, ever, forever, ever. And I'm telling y'all, if that's what it's going to be, I cannot go to a long trial. I will, however, cover it if, you know what, I might actually set it up to where I'm there for the last week of it so that I can be there for the verdict in the courtroom. But I don't know. I mean, I have time, clearly, because they have not been able to come together as far as the prosecution and the defense on discovery and other items. As you heard, there's a lot of different motions to suppress information that will be presented. So I guess we will get an update of what's appropriate for the public. And once they release that information, I will try to be on top of it and bring it back to you guys so that you guys are in the know. But again, this was a review of Bryan Konberger, his last hearing in court. And his next hearing, May 14th, will be closed to the public. But like I said, once there's any information released, I'll keep you guys posted. Thank you guys for joining me today. Midwife K, Apache Native, St. Hudson, Osun, Thank you guys for jumping in the conversation. Oh, Chantel, thank you guys for jumping in on the conversation psychologically in color. Is it psychologically or psychology? Psychology in color. My bad, girl or guy. It's a unisex name. But thank you guys for chiming in the comments. Bush babies, thank you as always. Going ahead and subscribe to the channel today. Set your notifications to all so that you're notified when I go live or add new content. And I'm Bush babies. I'm not going to let up. Y'all keep coming back to the channel. Clearly, you're enjoying the content. Just subscribe so that you're notified when I go live or add new content. Replay gang, definitely drop me some comments, like and share. I appreciate all of the support that you guys, my co-host, my day ones, my ride or dies, my Bush babies, and friends of the channel. I appreciate it. I feel it, and I'm really thankful. Thank you guys. Until next time.